put your hands around the throat of apparently your fiancée and choked her out. What kind of person does that?
Not a person in a good place and drinking like I was, Judge. I've had to live with every day that I put my hands on her and I lost my cool in a moment, and I just wanted her out in that time. I thought that that was the right decision. And in that moment, that wasn't ever the right thing to do with drinking. And I just wasn't thinking either in that time. I wanted her out, Judge. We were arguing.
Okay. So why'd you punch Layla in the stomach?
That never happened, Your Honor.
It's in the report.
That's what they say it is, but that never happened. I grabbed her and I moved her directly from my living room 10 feet to the door and out the door. My daughter had hit me at the time and I knew she was there. I did not stop in any time. Motion never hit my child. I have 7 children that I'm involved with every single day and raise, and even my other 3 that I don't get to see, that I still see them every weekend. But again, I'm not a violent person towards my kids.
So Layla lied to the police?
I believe it was a lie. She's had issues with that in the past. She's 9. Not with issues in this situation, but lying, and I think she was scared. I don't know, but I know that I never turned and I didn't put hands on my child.
The report says that she pushed you, trying to get you off of her mother, then you turned and punched her in the stomach, and she told the police that she had stomach pain after being punched by you.
I know that I did not turn and hit my child. I think that she was scared. I did not hit my child, Judge. I know that for a fact. She didn't push me. I was pulling her out the door. I had the door open, and she was hitting me on the side of my head and face, which I got that lip from it, but I did not ever stop at any point to hit my child. I believe the investigation as well. She admitted that she was lying through an investigator because she wanted me to be in trouble for her and her mother fighting. She felt that I needed to be in trouble for it.
So was Jessica lying when you said that you choked her out?
I don't think I choked her out, Judge. I did grab her, but I even told the officers as well. I did grab her by the neck and her coat that she had on and drug her out. I didn't choke her. Choking her, I don't know. But I did grab her by her neck and her jacket, the side of her arm, and yanked her and drug her out to the door.
The report says that you put 2 hands around her neck and choked her for about a minute.
That to be true, Judge. I was drinking, like I said, but I just grabbed hold and pulled out, moved her out. I mean, I obviously maybe choked her while that was occurring, but I didn't choke her.
You dragged her out of her house like somebody would drag a dog out of the house. They need to go outside, right?
That sounds like a lovely way. Just pulled her outside.
You dragged her out like a dog. No? Okay. All right. Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Your Honor, I'd like the court to consider that the 12-month cap was offered by our office. The recommendation from the agent was prison. People are sticking with that offer because of the statements we have had from the victim since. So I would ask the court to sentence pursuant to the offer that we made. However, I would ask the court to maximize the amount of time that he gets here so that when he's out, if he violates again, prison is all that is left. I think it is important to note that the minimization here leads me to believe that all of the work that is being done is simply for the purpose of looking good to the court and trying to avoid jail time. It doesn't actually seem to be anything genuine by the defendant. He just, every question, minimized what happened. You know, he said he just took her outside. Ms. Frost indicated to the officer that when he dragged her outside, he body slammed her so hard onto the porch that she urinated herself. The fact that his daughter, who he claims was punching him, but he put no hands on, felt the need to intervene as he was attacking her mother, I find that to be problematic. We have heard from the victim. She has indicated that she wants all of this dropped. She doesn't remember it and makes a point of telling our office that she can't afford to live without the defendant, that he pays the bills. I believe that this is a family that is in a situation where the fact that he is the provider is leaving them in a state of needing to be controlled, even in the last, 2 minutes where you questioned him. I know you heard this, but you asked him what kind of person chokes someone out. He said, oh, someone not in a good place who's drinking. And then later when you said you choked her, that's what it said. He said, why? I don't really think that happened. So I would ask the court to sentence pursuant to the offer that was made. We will dismiss the new charges as we said we would, but I would ask the court to consider all of that when deciding how much of this time you should serve and before making any decisions about the no contact order. Thank you, Your Honor.
One question for your,
Yes, Your Honor.
both of you. The 2024 domestic and district court here on the PSI, it shows it was pending with the sentencing date of March. Did he end up pleading to that? Was he sentenced on the domestic district court?
I don't recall he's putting on probation. 6 months. Yeah, he thinks he may have been on probation on that one.
I did 6 months of probation for district.
6 months of probation in district.
And was the victim in that case Ms. Frost as well?
I believe she was. She's here today.
Your Honor,
Yes.
my notes indicate that there was a deferred sentence on the misdemeanor domestic violence in the district court here.
Okay. They successfully completed the deferral?
It appears so because he was discharged from probation successfully on September 26th of 2025, Your Honor.
All right, the PSI says he's got 90 days credit, rated 2 days on this file, originally 2 days, then sentenced to serve 87 days with 87 days credit, and he served 3 days for posting bond on this probation violation. Does that sound right, Mr. Watkins? You served 87 days in jail?
Yes, sir.
Judgment sentence says you served 45 days, did 11 days credit, and you served 45 days. You ordered 45 days, 11 credit, you had 34 to serve.
Are you talking about the underlying charge, Judge?
Yeah.
Yeah, I think that, all right, so what had happened in that case, from what I recall, is that he bonded out, but probation thought he was still in jail while he bonded out, so that they had it 90 days of him serving where
So you
he,
served 45.
I think that's the number, Judge.
Okay. That's what we had as a credit for 48. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case. It would be the sentence of the court that this defendant served 7 months in the Nuevo County Jail. I'll give him credit for the 48 days that he's served so far. Is going to be continued on probation with the same terms and conditions as was originally imposed. Mr. Watkins, the court probably would have given you the 11 months or a year, but you have been, say, I'll use the term generously, you've been working on some issues. I don't know if you've just been going through the motions or if you've been actually working on the issues, but at least you're trying. You got a long ways to go. You can tell from my court's questioning and dissatisfaction with your answers, you still haven't internalized what you did, I don't think. But you spent a fair amount of money, you've been trying to do the right thing, so that's the only reason that you're getting 7 months and not the year.
Comment your opinion, like the video, and subscribe for more real courtroom moments.
The court addressed a domestic violence probation violation involving Mr. Watkins, who was accused of assaulting his fiancée during an argument while intoxicated. The judge began by confronting the defendant about allegations that he placed both hands around his fiancée's throat and choked her. Mr. Watkins admitted that he had been drinking heavily and acknowledged grabbing her, stating that he lost control during an argument and attempted to remove her from the house. However, he repeatedly minimized the severity of his actions, insisting that he did not choke her out, but instead grabbed her by the neck and coat and pulled her toward the door. The court then questioned him regarding allegations that he punched his 9-year-old daughter, Layla, in the stomach when she attempted to intervene and protect her mother. Mr. Watkins firmly denied striking his child, claiming she fabricated the accusation because she was upset and wanted him to get into trouble. He maintained that while his daughter may have been hitting him during the incident, he never retaliated. The prosecution challenged the defendant's version of events, referencing police reports stating that he choked the victim for approximately 1 minute and forcefully dragged her outside, allegedly slamming her onto the porch with such force that she urinated. The state emphasized that the child's intervention was particularly troubling and highlighted the defendant's consistent minimization of his conduct. Although the victim later recanted parts of her statement and requested that the charges be dropped, prosecutors suggested that financial dependency and family dynamics may have influenced her change in position. The court also reviewed the defendant's prior domestic violence case in district court, which resulted in a deferred sentence that he successfully completed. After confirming credit for time served and reviewing advisory sentencing guidelines recommending 0 to 11 months, the judge exercised discretion in sentencing. Ultimately, the court ordered Mr. Watkins to serve 7 months in the county jail with credit for time already served and to continue on probation under the previously imposed terms and conditions. The judge noted that while the defendant had taken some steps toward addressing his behavior, it remained unclear whether those efforts were genuine or merely strategic attempts to avoid incarceration. The court expressed dissatisfaction with his failure to fully accept responsibility, but acknowledged his financial and rehabilitative efforts as a factor in imposing a sentence below the maximum guideline recommendation. The judge concluded by emphasizing that although Mr. Watkins avoided the maximum possible sentence of nearly 1 year, his continued minimization of the offense raised concerns about whether he had truly internalized the seriousness of his conduct.